My name is Violet Mosiara. I am a partner at MMS Advocates. We carry businesses in Nairobi and Mombasa. This video, we are going to give answers to our clients, particularly in regards to registered companies here in Kenya that are facing financial distress. There are two legal solutions for such companies. One, the companies can select to go through liquidation. Two, to go through administration or company voluntary arrangement. For this video, I'm going to take our clients through the administration processes and what are involved in that kind of process. Just to mention, administration process is a new concept that was introduced in Kenyan law through the Insolvency Act.
What do you mean when you say a company is under administration?
While a company is under administration, when an administrator has been duly appointed to take over and control the affairs and properties of the company. Administration, loosely to say, is a second chance that is given to a company that struggles financially to meet its debts.
What exactly does a company under administration aim to achieve?
There are three objectives. One, to make sure that the company continues carrying on business. Two, to have a better outcome for all creditors as opposed to liquidating the company or shutting the company and exiting the company, exiting the market. Three is to collect all the assets, property of the company to ease distribution to creditors of the company.
You have indicated that an administrator has to be appointed. Who has authority to appoint an administrator?
There are three categories. One, the administrator can be appointed by court order. Two, can be appointed by the company or the directors or entities that hold security documents against the company. In legal terms, these are holders of floating charge.
Once an administrator has been appointed and the company is under administration, what are the effects of these actions to the company?
Well, there are varieties of action, but for purpose of this video, I'm going to narrow down. One, it's going to prevent the company from being liquidated. So if there's a creditor who intends to file a liquidation petition against the company, that is going to be prevented. Two, it's going to suspend already ongoing liquidation proceeding or pending liquidation proceeding. And three, there's a protective mechanism that the company gets the moment it's put under administration, which is called moratorium. Moratorium happens in two categories: against the insolvency proceeding, which I've already mentioned, stopping or preventing any liquidation proceeding, and two, against it stops the company from facing adverse legal action. What do I mean by this? In situation where the banks might want to go after the company's property once it hears that the company is under administration. For example, if the company owns assets that have been bought under credit transaction, then those people might not repossess those kind of properties. Three, any ongoing legal actions are stopped against the company. However, there is an exception to this scenario. Adverse legal action against the company can actually be instituted by approval of the court and by the consent of the administrator.
Is there any protection granted to companies under administration before the administration order is granted?
Yes, there is. I had mentioned earlier the categories of people who have power to appoint administrators. Before the administrator is appointed, actually this category of people have to issue out notice of intention to appoint an administrator. At the point that notice of intention to appoint an administrator is issued, then this moratorium is enjoyed by the company. I mean that legal action against the company are prevented. Two, at the point of filing an administration petition, before that petition is heard and determined by the court, then a moratorium is granted to the bank to protect its, actually it's just a preservation mechanism to avoid any adverse legal actions that can topple the company.
Once a company facing financial distress appoints an administrator, is that final for that company?
that is not final. Actually, what happens is the administration process now begins. This means the administrator takes over the control and management of the company, takes over the affairs of the company. Secondly, the second stage that follows is that the administrator announces that the company is now under administration. This announcement has to be made in the website, if that company has website, and all trading documentation of such company. At this point, actually, the administrator has power to remove or appoint the directors.
What happens after an administrator takes over the control of a company and realizes that this particular company has no assets?
Yes, that narrows down to the duty of administrator. He will do assessment, and after assessing the affairs of the company and realizes that this company does not have any asset to actually realize or collect for distribution, then a report is prepared, and the company is actually goes through dissolution. What I mean, the company is liquidated or the company is shut down and then deregistered and exits the market.
What if the company has assets? What happens?
Okay, if the company has assets, the assets are collected by the administrator and then it's distributed to all creditors of the company. Actually, during the distribution, all creditors might be paid wholly or partially. After such payment, and the company still has financial muscle to continue trading, then the company reverts back to trading as usual, and the administrator exits the company, and the company goes back to the directors. However, if after distribution there is no, the company no longer has any financial muscle, or basically there is no asset, or the company is no longer interested to continue with business, then the company can actually go through liquidation, dissolved, then deregistered, and exits the market. I hope this discussion has given answers to our client. Thank you very much for taking your time to listen to this.